Logan Paul spent millions of dollars on an inflated legal team to change the public narrative about his dealings with CryptoZoo. And for all that cash spent, nothing changed.
A fun game that earns you money. How much did you guys make from CryptoZoo?
I lost around $50,000 in CryptoZoo.
I lost $40,000.
And I lost around 15,000 US dollars.
I lost $25,000.
$120,000.
$500,000 Australian, which is $500,000 in CryptoZoo.
Shut up! No, you haven't!
Yeah, 500K.
Oh, no.
Good for you, but also you're slimiest. We're gonna handle this ourselves while we continue to build CryptoZoo, and I'll see you in court.
So by now, you've probably heard all about the CryptoZoo mess involving Logan Paul. After Coffeezilla published his investigation and accused the project of leaving buyers burned, Logan decided to take the fight straight to court and sue him for defamation. But after roughly 2 years of legal drama, massive attorney bills, and one headache after another, that battle has finally come to an end. And the deeper this case went, the messier it seemed to get. Logan and his legal team fought to keep his deposition away from the public, while critics pointed to disputed statements and courtroom arguments that only brought more attention to the controversy. Instead of clearing everything up, the lawsuit kept putting CryptoZoo right back under the spotlight month after month. But the way this whole thing ended isn't even the wildest part of the story. For much of the case, Logan's team pushed to keep his deposition sealed. That deposition was basically Coffeezilla's lawyers sitting Logan down, putting him under oath, and questioning him directly about CryptoZoo. And naturally, people wanted to know exactly what was said behind those doors.
In the Logan Paul v. Coffeezilla defamation case, the two parties are currently fighting over whether Logan Paul can mark his entire deposition as confidential. And in the last couple of videos that I did on this topic, I talked about how this is actually highly unusual to ask for an entire deposition to be marked confidential. And I talked about how Logan Paul's arguments for why it should be marked confidential are actually really weak.
Logan wasn't asking to hide one awkward line or black out a couple of pages. He wanted the entire deposition recording sealed. And that immediately raised a pretty obvious question. What was said in that deposition that his legal team was so determined to keep away from the public? Big shout out to Legal Bites, who's been breaking down the legal details throughout this whole case. According to that coverage, Logan's side gave 4 main reasons for keeping the deposition under wraps, but those arguments didn't ultimately persuade the judge. The first was that Coffeezilla supposedly couldn't be trusted with the material and might release it publicly or potentially hand it over to investigators. The problem? Those concerns alone didn't establish that Coffeezilla was doing something illegal. The second argument pointed to Coffeezilla allegedly providing information to the FBI, but cooperating with investigators isn't automatically illegal either. Third, Logan's side argued there was a protective order and that Coffeezilla was violating the spirit of that order. But according to the legal breakdown, the order itself didn't actually block him from sharing the material at issue. And then came argument number 4. Coffeezilla had reportedly shared material with attorneys involved in the CryptoZoo class action.
As a root problem, he doesn't make any argument that anything in the deposition is sensitive or private in nature. In other words, he doesn't really make any real arguments as to why this entire deposition should be treated as confidential.
But if that discovery wasn't confidential or otherwise restricted, sharing it with those lawyers wasn't automatically prohibited either. And that's the part that really sinks the argument. Across 4 separate reasons for keeping the deposition sealed, Logan's side never clearly explains what's actually inside the recording that supposedly needs to be protected from the public.
So here we're talking about how I think that in Logan Paul's reply, his lawyers did some things that can potentially backfire. And explaining this really starts with the weakness of his arguments. Let me put it this way. There's this old trial lawyer's saying that if you're weak on the facts but strong on the law, pound the law. If you're weak on the law but strong on the facts, pound the facts. And if you're weak on both, pound the table. Pounding the table is often thought of as being like forceful or aggressive in your tactics. But I actually like to think of it as any strategy to try to essentially distract from the fact that there really isn't much to your case or your position in this particular argument. But the thing is, depending on your strategy here, you could find yourself in the danger zone with the judge. And I think that is where we just might be in this particular issue. To start, Logan Paul's reply is an opportunity to strengthen the arguments from his original motion. It's supposed to be pretty limited in that it's supposed to be responding to the opposition, but nevertheless, it should be able able to use something to kind of bolster it somewhat. But instead of doing that, he basically repeats all of the arguments from his original motion, all of which, like I said, I think are already pretty weak.
Now, I couldn't find a picture of this table, but apparently it must have been one seriously impressive table, because instead of banging on about the facts or the law, Logan reportedly decided to bang the table instead. Not exactly the courtroom flex you'd expect in a case this expensive. Anyway, his reply was meant to strengthen the original motion, but according to the legal analysis, it mostly came back to the same 4 arguments that had already been challenged. And that became a major theme in this legal battle. Logan had far deeper pockets than Coffeezilla, and critics argued that continuing to fight over side issues increased the time and legal costs required for Coffeezilla to defend himself. Should the deposition stay sealed? Could discovery material be shared? Did somebody violate the spirit of a protective order? Those questions might matter procedurally, but they don't directly answer the central dispute over whether Coffeezilla's reporting about CryptoZoo was defamatory. Meanwhile, every new motion and filing meant more attorney hours, more paperwork, and potentially more money spent just staying in the fight. And when someone pushes this hard to keep testimony private, it naturally makes people even more curious about what's actually in it.
It's this hard to hide a deposition that helps them.
Now, to make matters worse for Paul, his lawyers at one point in this reply tried to do that thing that I described earlier. You know, where both sides will take the legal authority that the other side is using to support their arguments and try to show how it actually supports our side. But the problem is, as much as Paul's lawyers are trying to do that, in my opinion, I think they're very unsuccessful at it. For example, in this part of the reply, they're responding to Coffeezilla's argument that in order to mark his deposition as confidential, Paul needs to show good cause. And this basically means that Logan Paul needs to have a good, rational reason that has something to do with some kind of privacy interest. It's really not all that hard to do, but the problem for Logan Paul is that nowhere in any of these filings does he ever argue that he has good cause for making any part of his deposition confidential, let alone the whole thing.
Good cause basically means showing the court a real, reasonable reason connected to privacy or potential harm, and it's not exactly some impossible legal standard to meet. In a civil case, that could involve genuinely sensitive material, like medical records, private financial information, or other confidential details. Even then, courts can prefer narrowly redacting the sensitive parts instead of locking away the entire thing. But Logan's argument appeared to focus heavily on the possibility that the deposition could embarrass him, which by itself isn't necessarily enough to justify sealing everything. Then his legal team cited a previous case to support their position, and this is where the whole situation takes a pretty wild turn.
Instead, Paul tries to suggest that the case law Coffeezilla is citing to says it's actually a more lenient standard than what Coffeezilla is arguing. Specifically, Paul says defendants' own authorities recognize that the standard for designating non-filed materials as confidential is, quote-unquote, more lenient. And then Paul cites to this case from the Fifth Circuit, Hoa Lee v. Exeter Financial Corporation. But the thing is, although Paul says that there's like this more lenient standard, he doesn't exactly say what that more lenient standard actually is. And there's a very good reason for that. That's because if he did, it would naturally highlight the fact that the one thing that the Fifth Circuit says that Logan Paul needs in order to mark the deposition as confidential is good cause. Specifically, here's exactly what the Fifth Circuit says. In our view, courts should be ungenerous with their discretion to seal judicial records, which plays out in 2 legal standards relevant here. The first standard, requiring only good cause, applies to protective orders sealing documents produced in discovery. And then it goes on and actually says, under both standards, the working presumption is that judicial records should not be. So reading that, the Fifth Circuit is actually pretty clear that Logan Paul's motion should absolutely fail. Sealed.
And here's where things get awkward. They cited a case that appears to cut against the very argument they were trying to make, while never clearly spelling out what that supposedly lenient standard actually requires. Because once you look at the standard itself, it calls for the kind of specific justification Logan's argument was allegedly missing.
And by the way, not only is this understanding of this issue pretty common across the board in the United States, but the Fifth Circuit is also binding authority on the court that we're in right now with this lawsuit. In other words, the judge in this case is required to follow this case law. And I want to share a little bit more from this Fifth Circuit opinion because I think it beautifully illustrates why it's important for the public, you and me, to have access to this kind of information. For context, this case, Hoali v. Exeter Financial Corporation, involved two parties who basically agreed behind closed doors to keep like 3/4 of the discovery in that case marked confidential, and then to seal it permanently just so that the public could never have access to it after the litigation was over. And by all appearances, they didn't do this because this information was actually sensitive in any way. It's just the parties wanted to keep information private amongst themselves. And so the Fifth Circuit said in response to this, the public deserves better. The presumption of openness is law 101. The public's right of access to judicial records is a fundamental element of the rule of law. Openness is also civics 101. The Constitution's first 3 words make clear that ultimate sovereignty is wielded not by the government, but by the governed. And because we the people are not meant to be bystanders, the default expectation is transparency, that what happens in the halls of government happens in public view. Americans cannot keep a watchful eye either in capitals or in courthouses if they are wearing blindfolds. Providing public access to judicial records is the duty and responsibility of the judicial branch. Why is this important? Because accessibility enhances legitimacy, the assurance that things are on the level. Article 3 courts are independent, and it is particularly because they are independent that the access presumption is so vital. It gives the federal judiciary a measure of accountability, in turn giving the public confidence in the administration of justice. Put simply, protecting the public's right of access is important to maintaining the integrity and legitimacy of an independent judicial branch. And hopefully, more access to judicial records means more trust in judicial officers and more respect for judicial orders. Judicial records belong to the American people. They are public, not private documents. Certainly, some cases involve sensitive information that, if disclosed, could endanger lives or threaten national security. But increasingly, courts are sealing documents in run-of-the-mill cases where parties simply prefer to keep things under wraps. And so this opinion goes on. If you want to read more from it, which I highly recommend, I am linking to a copy of it in the description below. It's very passionate and very clear about how we shouldn't just be allowing parties to mark something as confidential simply because they want to keep it out of the public's eye. And oddly enough, that sounds like exactly what Logan Paul is trying to do here.
Fifth Circuit's starting presumption is straightforward. Court records generally should not be sealed from public view. So this isn't just some random case they can casually brush aside. The Fifth Circuit's precedent is binding on the judge here. That means Coffeezilla doesn't necessarily have to do all the heavy lifting, because Logan's own citation arguably undercuts part of his position. And considering the huge legal bills reportedly involved, that's a pretty brutal twist. The ruling itself is worth looking at because it deals with parties trying to keep large portions of a case away from public view simply because they would rather keep things private. That hits surprisingly close to the argument being made here. And the bigger issue goes beyond Logan. If court records could be sealed just because a wealthy litigant found them embarrassing or inconvenient, public access to the courts could become seriously uneven. CryptoZoo also wasn't some purely private disagreement. Numerous buyers said they lost money, while Logan publicly announced a buyback program after the controversy exploded. So there's an obvious public interest in comparing his public statements with what he actually said under oath.
So now that we see the weakness in Logan Paul's arguments here, I want to talk about the pounding on the table part. Specifically, here's where I want to talk about what Logan Paul's lawyers do that I think could end up backfiring. Now, there are actually a couple things that Logan Paul's lawyers do in this reply that the judge might not like, but I really want to focus on one of them. And basically, it looks to me like Paul's lawyers may have twisted the judge's words out of context in order to make their argument.
It's a bold strategy, Cotton. Let's see if it pays off for him.
Let me explain. So remember how in his motion, Logan Paul pointed to something that he says the judge said at some point. Specifically, Paul says, plaintiff has reason to believe that Mr. Findeisen and his counsel have routinely been sharing discovery materials from this case with the class action plaintiff's counsel, something this court expressed concern about when it decided to temporarily stay this case, and conduct which, again, constitutes use of discovery materials for purposes other than litigating the claims and defenses in this action. So now when you read read this, it sounds like back when the judge decided to temporarily freeze this case back in September, he had this super serious concern specifically about Coffeezilla sharing information with the class plaintiffs. But if you watched my first video on these arguments in this particular issue, you know that I looked back at the judge's September order staying the case, and I saw that the judge didn't say anything about this in that written order. And so in that video, I said, the only thing that I can really think of is maybe the judge made some kind of a comment at the hearing just before this written order came out. And as it turns out, in the reply, we finally get to see that that's in fact where Logan Paul's lawyers are getting the idea that the court expressed this concern about the sharing of information. Specifically, Paul's lawyers attach a very small bit of transcript from this hearing to show this. It's really not enough to get full context on what exactly was being said, but we can basically put together more or less the main gist of it. And the thing is, now that I've seen at least this much of what the judge said here, based on how much I can put together, it kind of looks like Paul's lawyers may have twisted some things here.
If the deposition seriously conflicts with statements he made publicly, that could create a major credibility problem. But without seeing the testimony, nobody can fairly claim that contradiction exists yet. And then Logan's lawyers made another move that carried some serious legal risk. Then the filing claims the judge was concerned about Coffeezilla sharing discovery material with the lawyers handling the class action. But here's where things get messy.
And if that's the case, that is a problem for them, because that would mean that they are twisting the judge's words to the judge. Let's take a closer look so you can know what I mean. So this hearing transcript that Paul attaches starts out where the judge is talking about Coffeezilla's earlier request to transfer the case from San Antonio to Austin so that it can be litigated in the same court as the class action case. And there's discussion leading up to this that we can't see, but he basically concludes that he doesn't want to transfer the case over there. So the judge says at the top of this page, "So I'm wondering, I will tell the parties the motion to withdraw, the transfer to withdraw. I'm not transferring this case to Judge Griffin. It would not be fair. I've already had involvement in this case. He's got enough on his plate. But I am considering staying some or all of the proceedings in this case while that case gets rolling. I need to hear from the parties on it. I'm concerned about it. Judicial resources need to be economized. There is the danger of prejudice to both sides. I'm very concerned, even though there's a voluntary agreement by these potential class members to subject themselves to deposition, I'm concerned that that could be prejudicial to them. I'm concerned with the team on the Logan Paul side that some of this information would be information that could be used in the other case, even with the protective order. And the flip side, of course, anything that was disclosed by defendants in this case to Mr. Paul, how could he not use that in that case? I'm worried. I do not want to prejudice the parties. I need to hear from the parties as to how to address these issues. It's separate from the motions in front of us. I'd like to start with the plaintiff. So it sounds like what the judge is really saying here is, we have these two cases where one person is a party in both of them, that's Logan Paul, and then you otherwise have other people who can be affected in one case by something in another case that they're not even involved in. And so rightly, the judge is worried that there are things that can happen here that could lead to an unfair prejudice to one or another side, and if these parties start to engage in discovery funny business.
Go back and read the judge's written order from September, and that supposed concern doesn't appear there at all. Instead, the filing points to a small snippet from a hearing transcript, without the surrounding context that could show exactly what the judge meant. And you can see why that could be a risky move. If the filing is presenting the judge's own words without their full context, they're making that argument directly to the person who originally said them and knows exactly what was meant. But then came something potentially even more damaging, the apology video Logan released.
Coffeezilla is not a criminal. I called him, I apologize. Step 2, we want to offer a rewards program for players who are disappointed in the status of the game. So essentially, you're going to be able to burn your base egg or your base animal for the mint price, which was 0.1 ETH or the equivalent in BNB. I am personally committing 1,000 ETH to this, which is about $1.3 million. I'm sorry, guys. I apologize for how this has unfolded thus far, and I want people to know that they can trust me and that I'll always take care of the fans and people who support me. And lastly, thank you, Coffeezilla. You have catalyzed this, and I am very grateful for your work and your investigation, and I mean that. Thank you, bro.
And here's what you need to remember. Critics have accused Logan of saying one thing publicly while taking a very different approach behind the scenes. In his apology, he said Coffeezilla was right, thanked him for his reporting, and committed 1,000 Ethereum toward refunds for CryptoZoo buyers. That sounded like a major turnaround, but then the actual buyback offer showed up, and things got complicated fast. The buyback reportedly covered only around 12% of the estimated damages, while requiring participants to give up certain claims against Logan and related parties. To critics, that looked less like a full refund and more like a settlement-style deal with some serious strings attached.
Logan Paul is refunding people he scammed if they promise to stop suing him for the vastly larger amount he may owe them. And honestly, I'm conflicted because on the one hand, victims getting money is always great, and I'm proud that our investigation led to some real-world consequences. But I can't pretend that things are fixed or fine for people who entrusted me with their story when that's just not true. So here's the real, more complicated story in 3 parts: the refund offer, the Zoo tokens, the lawsuit, starting with the most important part. And if you get one thing from this story, this should be it. These are the estimated damages in CryptoZoo, $18.5 million, which comes from a combination of ZooCoin and NFT sales. And then this, much smaller percentage of that pie, is what Logan is actually offering to refund, on the condition, though, that all of the people who spent the last year suing him for the larger damages drop their case. So that's a refund of only 12% to drop 100% of the case that, as far as I can tell, Logan may be losing.
And there's another awkward twist here. Earlier in the legal fight, Logan pushed to have the case moved to San Antonio, partly because information could potentially move between the related lawsuits, and that apparently wasn't a problem when it could benefit his side. But once information started potentially flowing the other way, his team suddenly raised concerns about that same kind of sharing. That contrast is pretty hard to ignore. But according to the court's reasoning, the judge didn't appear especially worried.
And the reason this probably came up is because, remember, the judge started out here in this hearing transcript talking about Coffeezilla's motion to transfer the case. If we look back, in that motion, Coffeezilla made the argument that the whole reason Paul filed this lawsuit was to purposely engage in funny business. Specifically, one reason was to punish Coffeezilla, and then the other was to get around roadblocks that came up in the class action case and to gather discovery from Coffeezilla that he could use in the class action case and during a time when the class plaintiffs weren't able to collect any discovery against Paul. So with that in mind, when we look back at this hearing transcript that Logan Paul has attached to his reply, let's home in on one part specifically. The judge says, "I'm concerned with the team on the Logan Paul side that some of this information would be information that could be used in the other case, even with the protective order." What that means is the judge is actually recognizing that the protective order can't necessarily stop Coffeezilla from sharing non-confidential information with the class plaintiffs. And then, importantly, the judge immediately also says, and the flip side, of course, anything that was disclosed by defendants in this case to Mr. Paul, how could he not use that in that case? Again, he's saying, how could he not use that in that case? That means he's once again acknowledging, I know I can't stop Logan Paul from using discovery over there after he gets it over here. And so what we can piece together is that the judge here isn't saying, hey, Coffeezilla, you're not allowed to share information with the class plaintiffs at all. And to be clear, that is actually what Logan Paul is trying to suggest in this current argument over his deposition. But rather, what it sounds like the judge is actually saying here is, I'm worried about all of this just turning into a huge mess where both sides start to abuse the discovery process across the board to get an unfair one-up on each other between these two cases.
About Coffeezilla, the bigger concern centered on Logan's position in both cases. Logan was involved in both lawsuits, creating the possibility that discovery obtained in the defamation case could potentially be used in the CryptoZoo litigation against people who weren't even parties to this case and therefore didn't have the same access in return. That imbalance mattered. It was part of why the judge refused to transfer the case and even considered putting the proceedings on pause. And that's exactly where the transcript snippet cuts off. We don't get to see how the lawyers responded, how the rest of that exchange played out, or where the judge ultimately landed during that discussion. And if the judge had formally adopted Logan's position, you'd expect that reasoning to show up in the written order that followed. So taken together, Logan's repeated efforts to keep the deposition sealed certainly made it look like keeping that testimony private was a major priority for his team.
And importantly, then the judge also says, okay, attorneys on both sides, give me your thoughts about this. That is signaling that this is the beginning of a discussion with both sides. And unfortunately for us, Paul does not attach more transcript here to show how that conversation went, what the attorney said on either side, or what the judge said at the end of it. So for our purposes, there's this really big question mark as to where the topic settled at the end of this hearing. But the reason I personally doubt that the judge ended up feeling just as concerned at the end of all of this is, again, he didn't say anything about this in his formal written order that followed up this hearing, and he totally could have if he had wanted to. If he was still concerned, he likely would have reminded the parties about that concern in that written order. However, although we can't be sure from this vantage point that you and I are sitting in, the judge obviously was there for the hearing, and he most likely remembers why he was concerned and what he said and how he felt at the end of this hearing. And in my experience, judges don't often take too kindly when they think that one party is taking something that he or she said before and then twisting that into something different. And that can result in a verbal lashing from the judge in response, or it can also just mean that over time, the judge starts to build this feeling of disdain or annoyance or mistrust against your side. Remember, judges are human too, and they develop a sense over time about the attorneys that are in front of them. Who's professional, who's honest, and who's maybe not so much. And throughout litigation, there are many decisions along the way where the judge has to use his or her discretion. And sometimes if the judge thinks that you have a pattern of being dishonest or unfair, or that you often engage in dirty litigation tactics, that can leave a subtle impression that can make a difference later on down the line when it really matters, when the judge is making one of these discretionary decisions. And so, if I'm reading this correctly, I think that Paul's lawyers might be running the risk of creating a negative impression with the judge at the very least. And that ultimately can, of course, backfire.
Then, after a long stretch where the case went unusually quiet, the next big development finally dropped. Logan and Coffeezilla had settled the lawsuit outside of court. After years of filings and what were reportedly massive legal costs, the whole thing ended with a private settlement behind closed doors, without the defamation claims ever reaching a full trial. And that also meant the deposition everyone had been fighting over never became public.
After years of drawn-out civil litigation that's undoubtedly cost millions of dollars, Logan Paul and Coffeezilla recently quietly settled out of court.
So whatever Logan said under oath remains out of public view, and the settlement terms are private too. That means outsiders don't know whether money changed hands, how much was involved, or what conditions either side agreed to. But when you look at how this case unfolded, the money was never really the most important part of the story anyway.
What did each side actually need in order to quote-unquote win? Coffeezilla walked in with the public already on his side. He did not need to sway anybody with new evidence. Instead, what he needed to do was survive this lawsuit without going bankrupt. But then we look at Logan Paul. He needed public opinion to flip. That's where he was actually impacted in this whole saga, and the settlement money alone wouldn't fix that. I mean, remember, this is a self-described petty billionaire. Whether Coffeezilla paid him $0 or millions of dollars, that money changes nothing about Logan Paul's life because it's essentially probably a drop in the bucket. So arguably the only way that any settlement amount really means anything to Paul personally is how much his ego thinks it hurts Coffeezilla. And the thing is, we know Paul cared very much about hurting Coffeezilla financially through this lawsuit because he texted as much with his buddies.
As Legal Bites pointed out, it's difficult to know whether Coffeezilla walked away from this financially untouched, especially with the legal costs involved. But one thing is obvious from the outside. He's still making videos, still investigating crypto stories, and he kept publishing throughout the lawsuit. So if the goal, or even the practical effect, was supposed to pressure him into silence through expensive litigation, that clearly didn't happen. And that's where the whole situation takes a pretty wild turn. Logan sued Coffeezilla over statements connected to the CryptoZoo controversy, but the lawsuit itself kept those accusations tied to Logan's name for roughly 2 years. Court filings, legal coverage, news stories, and online discussions repeatedly revisited allegations involving words like scam and scammer, even though those remained accusations rather than a court finding.
And in this case, I have to be blunt, that vindication never came. There's absolutely nothing from discovery or any of the arguments in court papers or any other part of this litigation that moved the public towards Paul. If anything, his reputation actually got worse through the course of this litigation.
Instead of making the CryptoZoo story disappear, the lawsuit arguably gave the controversy a much longer shelf life and brought fresh attention to claims that might otherwise have faded after Coffeezilla's original reporting. And critics saw the settlement itself as the final twist. A trial would have given Logan the chance to argue in front of a jury that Coffeezilla's videos were defamatory, with both sides presenting their evidence in open court. But instead of taking the case all the way to a verdict, the two sides settled privately. Now, that does not legally prove Coffeezilla was right or Logan was wrong. A settlement isn't an admission of liability.
When a plaintiff doesn't really care about the money because the amount isn't really going to make that much of a difference in their life, a settlement really only means something if it comes with something more. That might be something like a public apology, or like the defendant saying, I lied, or at the very least saying, I shouldn't have said what I said. But the thing is, there seems to be zero evidence of anything like that going on here. So this is what all of this adds up to. Logan Paul spent millions of dollars on an inflated legal team to change the public narrative about his dealings with CryptoZoo. And for all that cash spent, nothing changed. He effectively burned all that cash for absolutely nothing. In short, this lawsuit was a big fat failure for Logan Paul.
Still, after years of fighting, Logan walking away without the public courtroom victory he originally pursued inevitably shaped how people viewed the outcome. To plenty of people watching, that spoke louder than any victory lap could have. So look at what's actually left standing after this entire legal battle. Coffeezilla's videos are still online with the word scam in the titles. And as far as the public record shows, they weren't retracted or edited because of this lawsuit. Meanwhile, Logan's deposition never became public, meaning we still don't know exactly what he said about CryptoZoo while under oath. And the CryptoZoo class action is still a separate fight, so the people seeking to recover their alleged losses haven't gotten a final resolution through that case yet. While all of this played out, Logan also spent serious money fighting a defamation lawsuit that ultimately ended without a public trial or verdict. That's the real scoreboard here, and it's bigger than simply asking who paid who. So here's the question. Did Logan settle because he was finally ready to leave the Coffeezilla fight behind, or because continuing the lawsuit risked bringing even more attention to CryptoZoo and that hidden deposition? Drop your take in the comments below, and if you enjoyed the video, hit the like and subscribe buttons, and I'll see you in the next one.